my name's Tiffany, and I'm going to review the documents that you'll be seeing at your signing meeting when you come in for the next few days. This is just a brief overview. This will give you a little bit more understanding of what you're coming in and signing, and then you can bring the questions that you need to the signing meeting when you meet with one of my team members in the funding department. At the end of this meeting, we will create something that's called an asset detail worksheet. And what this does is it provides us a listing of all your assets so that we can create an asset detail report that we'll review with you at your funding meeting. So if you have any of your bank statements, your CDs, any kind of asset that any kind of documentation that you have, if you want to bring it to your signing meeting, that will get you a step ahead and you won't have to stop back in the office. So that would be any bank statements, your 401ks, your life insurance, your any CDs, any money markets, any life insurance documents. If you'll have those, that'll be great for you to bring in because we'll ask you those for that. But we'll also review this at your signing meeting as well at the end. And then that way, after you get the trust established, then we'll fill out that asset detail worksheet, and then we'll ask you to bring in your statements, and then we'll make recommendations on what can go into your trust and what can't go into your trust. So right now, there's a lot of questions out there of how things will work. And so once you have that funding meeting, everything will come together, and we'll review that asset detail report along with giving you letters of instruction that you will take with you to your banks to get things set up like payable upon death, or we can get mail out letters for you to get the documents you need to change beneficiaries for your life insurance. So we're not going to just say, here's your trust and have fun funding it. We'll walk you through that step by step, but we just need your cooperation in providing us the statements in order to prepare that asset detail report. So I'm going to go ahead and share my screen. So then that way we can get moving on our documents. So the first document we're going to go over is the General Durable Power of Attorney, otherwise known as the Financial Power of Attorney. What this document does, it's basically gives the other person that you name or other persons that you name the ability to act on your behalf for financial matters. So basically typically it's naming the spouse. So in this case, we have, we'll zoom in on this. Let's see if it'll let me do this. Yes. I'm going to go 100%. Okay, there we go. So in this one, we have John Sample is the husband, and his wife is Mary. So it's basically saying that I, John, give Mary the ability to act on my behalf in financial situations. If for some reason Mary's unable to, then it goes to John Jr. and Sample. They can act in unison or independent of one another. So basically what this is saying that they can act by themselves or they can act together. So this means that if you have to do a real estate transaction, you don't need two signatures on there. They can do it themselves. This document is long because in Ohio, it has to name one by one each thing this person can do for you. If they help manage your bank accounts, pay bills, manage your real estate, file taxes, pretty much anything you can do for yourself, they can help you with it. Note that this does go into effect immediately. So the agent could start helping you today. So General Durable Power of Attorney. Like I said, it's long because it lists everything that they can do. Main thing is we're going to have you sign 2 copies because one we're going to send home with you in your binder, and we're going to keep one on file because real estate transactions require you to have an original. So if something happens to that original, we'll have that as backup. So just wanted to let you know that we have that. So that was the General Durable Power of Attorney. The next document we're going to go over is the trust. So basically the first few pages are the table of contents. So if you need to find out where something is, this is where you'll go in the trust. So it lists everything, where everything is, and at the end in section 11.06, it'll have the definition. So once you find it and you read it and you don't understand what you're reading, you can go back to section 11.6 and it'll give you the definitions. Article 1 is going over the general provisions of the trust. So it's an overview. It's going to say that you're the grantor and you're the trustees. And then it's going to give you the name of the trust. This one is the Sample Family Trust. However, the following format should be used for title for taking assets. So if you're going to open a bank account in the name of the trust, it should read John Sample and Mary Sample, trustees of the Sample Family Trust, dated. We'll go over this with you in more detail, but just know that it's here. Our section 1.3 is going to say that the trust is irrevocable. I always like to point this out because it's not as scary as it sounds. Even though it's irrevocable, you can still make changes to it. You can change your beneficiaries, you can change your trustees, but the irrevocable part is what gives you the asset protection from the nursing home. So I'd like to bring that up. So the trust will always exist, but yet there might not be anything in it. Section 1.06 goes over your family information. So it's stating that they're married to each other. We have 2 children. We always ask you to check spellings and check birth dates because we always get those mixed up. And then section 1.07 goes over your lifetime beneficiaries. Do you remember when you were talking with the attorney and he said if you wanted to get something out of your trust, then you'd have to go through, at this point, it is John Jr. and Ann. So this is just designating who those people are that you can use to get money out of the trust. It doesn't mean that they are going to receive anything, but in this case, most of the time, they are part of your beneficiaries. Article 2 goes over trustee succession. So if you're married, in this case you are, if one of you is unable to act, the other one can act as sole trustee. If neither of you aren't able to act, in this case, it's going to say that John Jr. is going to be up second, and then it'll go to Ann. So this is during your lifetime. So if you decide that you don't want to be trustee anymore, that's fine. You can appoint John Jr. and if John's not available, it can go to Ann. After you pass, after the second of you pass, then John Jr. will be the trustee of the subtrusts, and then Ann will be the backup for that. So that is yes. Article 3 goes over the administration of the trust. So basically, this is just stating that Article 2 is a little bit long because it lists everything in. Oh, I did want to bring up this point. Provision for trust protector. So in this case, the trust protector for this trust is Timothy P. Jarvis. What that means is if there are any changes to the trust, they have to go through the trust protector. Meaning if you make a change, then Tim will need to sign off of it. If there's some change in the law that Tim is notified of, Tim will make it known to you and let you know that is changes are need to be made. It is basically just protection so that you can't just make changes that will maybe make the trust not a Medicaid asset protection trust anymore. So Article 3 is the administration while you're living. So this section really refers to your property. This section is going to say, even though you transferred your home into the trust, you don't have to pay yourself rent or anything like that. Section 3.1 is also talks about the homestead exemption. So if you have a homestead exemption now, that will transfer to the trust as well, stating that the trust can hold those homestead provisions. Article 4 is specific distributions and tangible personal property. So it basically is just saying, referring to your stuff and things, jewelry, tools, your couch, non-entitled assets. So basically it's going to say that if you have specific things that you want to give to certain people, that it'll go here. Specific distribution. In this case, the example is the trustee will distribute 1,000 each to our grandchildren and living at this time outright and free of trust. That's an example of a specific distribution. The other section I like to point out here is the 4.02, distribution of tangible personal property by memorandum. The memorandum is, I'm going to bring this document over so you can see what this is. basically it's stating that if you want John Jr. to have all your tools, you'll go here. All my woodworking tools will go to John Jr. And then you would date and sign it. So then that way the trustee knows that you want these things to go to certain people. So it could be tools, it could be pictures, it could be jewelry, but this is a document so your trustee will know who you wanted certain things to go to. If it's not listed on this personal property memorandum, then that's when our next section will go into effect. It's Article 5, Administration of Remaining Trust Property. So if it's not listed as a specific distribution or listed on that personal property memorandum, it's going to come here in Article 5. And for Article 5, it's going to say John Jr. gets 50%. Go over, distributions will be handled. It could, depending on how you discussed it with the attorney, it could be per stirpes or pro rata and per descendants. Easy for me to say. The other thing that we like to bring out is if nobody is living, let's say John Jr. is passed and Anna is passed, we have the remote contingent distribution, which I'm going to go over next. So that's Article 6. And it's basically stating, Article 6 states that if there's nobody living listed in that is to get any of the inheritance of the trust, it's going to take 50% of the remaining trust and give it to the husband and 50% and giving it to the wife. We do this, we put this in every trust so that way it doesn't go to probate. It's giving it somewhere to go. So Article 7 is the same as another thing that we put in every single trust. It's the supplemental needs trust. It's basically stating, I'm going to read this. It's going to say, we're not going to go into too much depth, but it's going to say that this section is going to say if your beneficiary was on a benefit that is means tested, meaning they can't have more than $2,000 in their name, that they would receive their share pursuant to this article to ensure that they don't get kicked off their benefits. So means tested means, so if they would receive their inheritance pursuant to this article, it would make sure that they could receive what you left them without getting kicked off their benefits and losing their income and health insurance. They're going to be on special rules on what they're able to use the money in their subtrust for. We'll say they can't use the funds for expenses that their disability benefit will cover, like rent, insurance, medical, but they can be used for extra things such as clothing, furniture, items beyond the necessities. So this is basically giving them the money that you wanted them to have without kicking them off their disability or letting them lose their insurance. But there's this article is long because there's certain things and it's done by the government. But we put this in every trust because we don't know what's going to happen in the future. We want to make sure that your beneficiaries are getting the money that you wanted them to have, even if they're on means tested. Article 8 is going over administration for trusts for underage and incapacitated. So in this trust, the underage, anybody under the age of 25 would have their money in a subtrust that the trustee will manage. Once they're 25, then they can become the trustee of their trust. So basically it's stating that they won't get their money until the age of 25 unless they petition to the trustee that they want to have, they need their money for education, and the trustee can say yes. Article 9 goes over the terms for trust administration, which is the process for distributing your stuff to your beneficiaries after you pass away. This is more instructions for your trustee at the time. A few sections we like to point out is no court proceedings, so it doesn't have to go to probate, that's part of the reason why I'm sure you set up a trust. No bond. You're not going to make your trustee, after you pass, pay money to manage your money. So exoneration of your trustees. Your trustee isn't responsible for how you managed your assets during your lifetime. The next one is information to the beneficiaries. This is really most important part, just keeping the other beneficiaries informed of what's going on and what timeframes to expect, or they can start getting antsy. So basically that means that they just keep in communication with everybody. Also, it says what else the trustee can get compensated if they have to take time off work. They just need to make sure they keep a detailed record. If they have to employ professionals, either a tax person or a survey, that can be paid out of the trust. So that is section 9, which goes over trust administration. Article 10 goes over trustee powers. Trustee powers are, as once we get to it, Article 10, here it is, trustee powers. So basically, this section talks about the powers you have to manage trust assets. For example, you can pretty much own any type of an account in the name of the trust other than a retirement account, such as an IRA or a 401k, so that you can manage an investment, bank accounts, business, life insurance, and real estate. So this is just stating that the trust can hold bank accounts. It can hold a CD. It can hold investments. This is just giving you the trustees the power to do that. And it can hold oil and gas, mineral interests as well. Scroll through this. The next section is Article 11, Article 11, and that's our last article. And the things that we like to go point out on Article 11 when we get to it, I will scroll and see if there it is basically 11.03, the contest provision. And this section refers that if you're one of your beneficiaries were to contest or sue your trust saying they deserve a bigger share than you left them, they would get completely out. This is more of a deterrent than anything, but make sure that what you put in writing is what actually happens. So this is stating that like the youngest can't come and say, well, I get more money because I was the youngest or I was the favorite. And if they do that, then basically they get nothing. Our section 11.06 is the definition. So at the beginning, I stated that here's the table of contents when you find something, and then when you need to figure out what that word means, then here's where you come with the trust. All righty, so that is a quick overview of the trust. And the next document we're going to go over is the certification of trust. It's basically the nuts and bolts of that huge 60-page document that we reviewed. This is the document that you would take if you were going to go open a certificate of deposit, or if you're going to open a bank account in the name of the trust. It's basically the name of the trust, it currently exists, the date that it was executed on, but most importantly is line 10. And I reviewed this at the beginning, how assets need to be held. John Sample and Mary Sample, trustees of the Sample Family Trust, dated January 1st, 2021. So this is how that you would want to see your trust accounts listed as. It's kind of confusing because it lists your name there and not just the name of the trust, but that's how assets need to be listed. So this is something that will be put in your binder, so you'll have that. And we'll also the tax ID is basically one of the grantor's social security number. So but it's formatted in as tax identification, but it's using one of your social security numbers, and we'll review that during the signing meeting, but I like to bring that up as well. The next thing we want to go over is the quick claim deed. So basically this is just a sample one saying that you as individuals are releasing all rights to the property and you're going to put it into the trust with the address and everything like that. So you'll just need to check the information there. And this is something that we will record for you unless you state that you want to do self-recording, which you are more than happy to do that. But we would also need to fill out this memorandum of trust. So this is similar to the certification of trust, but just the stuff that the county will need to record the deed. So basically saying the name of the trust and everything like that. Let's see. The next document we have is the assignment of personal property. So basically, this is you saying that you want all your stuff and things put into the trust. So you don't have to list everything out and say that here's everything that's going in the trust. This is putting any non-titled assets in the trust. All right, so we have that assignment of personal property, and we already went over the personal property memorandum. That's how you're going to make certain things for certain people. The next document we have is the will. The will is basically just a document that is going to say if something has to go to probate, which we hope it doesn't have to, because we're going to set everything up with beneficiaries or list a payable upon death or transfer on death. But if for some reason you purchase a property or you find that you have a property that you didn't know about that you inherited, this is stating that you want everything to go into the trust and that you designate typically each spouse, and then if as the executor of the estate, and if Mary's not available, then it goes to John Jr., then Anne. So basically, we hope that we don't have to use this because that means we had to go to probate, but we have it just in case. And this is the only document that your notary can't sign. We'll have to bring somebody in to be a second witness on this. But that is the will. I'm going to end this video and I'm going to do another video that reviews the healthcare documents so that you have those. Those are 3 documents that will review your healthcare power of attorney, your living will, and your HIPAA. So for now, that's all reviewing the trust documents. You can replay this video and hit pause and figure out what questions you have. But remember, at the signing meeting, if you have any of your bank statements, your life insurance, your annuity paperwork, bring that in and we can get it scanned. So then that's one less thing that you have to remember to do. But we'll review that at the end of the meeting and go over that asset worksheet so we can make sure we have all of your assets. Thanks for your time.